Good evening, everybody. We'll start with the Real Estate Regulation and Development Act 2016. There were five-fold objects to start this act: to establish the Real Estate Regulatory Authority. Like in 1992, there was a big scam in stock market and the SEBI came into the picture. So what was the SEBI role? To stop the insider trading, to stop the manipulation. Similarly, in real estate, there were a lot of manipulation done by the builders. They would not give you the exact carpet area. They will give you the build-up area, then super build-up area. So you were getting only 500 square feet of flat, but the builder used to give you 1,000 square feet. He used to charge for 1,000 square feet. So by bringing this Real Estate Authority Act, that is called RERA in Maharashtra, like SEBI is controlling the stock market and the corporates, similarly, this RERA will control and see that there is a smooth running and there is accountability and transparency and there is no manipulation. Like the builder has to maintain his website on the RERA website. He has to give all the details that what will be the exact carpet area, what will be the common areas, what will be the garden area, what will be the swimming pool, clubhouse, everything he has to reveal it. He cannot say, I will do this afterwards. Plus, the main benefit is the builder has to upload the draft agreement. Initially, before coming the RERA into the picture, the builder used to take the money but never execute the agreement. And if he executes the agreement also, he will not mention the possession date. The possession date was kept blank. Now with RERA coming into picture, the builder has to say how much carpet area as defined by the RERA authority. What comes into the wall is counted as carpet area. Balcony or terrace, they are not counted in the carpet area. So within the four walls, the external walls, whatever you get is the net carpet area, including the column and beams, they are not deducted. So that is one benefit. And then he has to mention the possession date. Initially, the builder never used to mention the possession date. Means majority of the builders, say 70 to 80% of the builders never used to mention the possession date. Now you know the draft agreement. Now what you have to do is, you take a printout of the draft agreement, go to your advocate or your legal advisor, pay him some fees, say around 5,000, 10,000, vet the agreement that this agreement is as per RERA or not. Initially, there was not this system. The builder will call you, by kal aapko stamp registrar office mein aana hai 11 baje aur aapko register karna hai. So you go running there, you wait in the queue, then you are sitting in front of the camera, your fingerprints are taken, your photo is taken, and your signature is taken on the agreement without you seeing what is the content of the agreement, and the possession date is kept blank. Now with RERA, you can vet the agreement well in advance, and if there is any discrepancy, any ambiguities in the agreement, you have the full right. You have the full right to point out that discrepancy into the RERA authority, that this is not as per the RERA agreement. So this is how the RERA is ensuring that there is an accountability, there is a transparency, and there is no manipulation, either on the possession date or in the area. And the second point is the promotion of real estate sector. The third point is to ensure the sale of real estate project in efficient and transparent manner. Fourth, to protect the interests of the home buyers in the real estate sector. To establish an adjudicating mechanism for speedy dispute redressal. Now I will say that RERA gives you an speedy and affordable justice. Initially, say for example, if your flat value is say around between 1.5 crore to 2 crores, and now you think that the builder is not giving me possession or builder is not doing the construction, and you decide that I will go into the High Court. Now, when you go into the High Court, what happens is the flat value is around 2 crore rupees. So minimum court fees is around 3 lakh rupees that you have to pay to the court. And your advocate is also going to charge you similar fees because it's going into the High Court. So 3 lakhs plus 3 lakhs, how much it becomes? 6 lakhs. Plus xeroxing and incidental charges, and then commuting from, say, from Andheri to Churchgate. And now when you lodge your suit for a specific performance, the builder is flooded with money. He will hire a very good counsel who has a face value. Now your advocate will also give you ideas that to counter this, we'll also have to keep an counsel equivalent to the builder's counsel. So again, there is a figure of 2 to 3 lakh rupees for counsel. So approximately for a litigation, you have to spend around 9 to 10 lakh rupees. But when with RERA coming in force, the RERA fees is only 5,000 rupees plus something here and there. So it will cost you around 5,100 rupees approximately. And plus, as per the book and as per the act, you have to, the authority has to dispose your complaint within 60 days. But practically it doesn't happen that way. Instead of 60 days, you count 120 days or 150 days max to max. Or you have an option, you can go to the High Court and say that my hearing is not taking place. You can file a writ petition and see that your complaint is redressed or addressed or the order is passed within another 4 weeks. So this becomes very economical. Of course, initially, people used to file complaint in person. They did not used to hire advocates. Now, when you go there and you make some silly mistake, the advocate of the builder is going to take the undue advantage and will linger or will, some excuse or other. So it is advisable to hire a professional in the RERA so that your complaint is filed properly and you get the right justice. Now we go to the next slide. Important aspects under RERA. Provisions pertaining to the following: promoters, real estate agents, allottees, that is consumer, the home buyers, consent authorities, and miscellaneous. Promoters, dear Mr. Promoter, say hi to the key to your treasure box, because registration is builder's treasure box. They have to register their project on MahaRERA website, Maha Online. So if they don't register, they have no right to sell any flat. So registration is the key to the treasure box of the builder, because until and unless they don't register the project, they cannot advertise or they cannot sell any flat. No promoter shall advise, market, book, sell or offer to sell or invite person to purchase the flat, apartment or building in any real estate project in any planning area without registering the project in RERA. Oops, section 59. The penalty will be from 0% to 10% of the estimated cost of project. So now any project, if you see in Mumbai, will be costing somewhere around from 200 crores to 10,000 crores. Just imagine if 5% of the penalty is levied on the cost of the project. His 50% of the profit will go in paying the penalty. So this is a very good move by the RERA and it is highly appreciated. If the above penalty is not paid and violation continues, promoter shall be punished and there can be a jail term to extend to 3 years, or fine, which may extend to further 10% of the estimated cost of project, or both. If there are penalty of 10% 2 times, the whole profit of the builder will go in paying the penalty. So now the builder will be very careful. They will deliver what they promise. Validity of registration till the date of completion as stated by the promoter. Now suppose if the promoter or the builder registers his project in 2018 and he promises that he will give the possession by 2022, but if the project is not completed by 2022, he will get further extension and the registration is valid till he completes the project. Extension of registration. Registration may be extended due to the circumstances force majeure, namely flood, drought, fire, cyclone, earthquake, and other natural calamities. See Section 6 of the RERA Act. Now we have faced this pandemic. So the 6 months extension is given to all the builders. Exemptions from registration. Area of land proposed to be developed does not exceed more than 500 square meters. Number of apartments proposed are less than 8. Where promoter has received completion certificate prior to 1st May 2017. So the act came into effect from 1st June 2017. If the occupation certificate is obtained by the builder prior to 1st May 2017, he does not have to register his project, because once you obtain an occupation certificate, the project is supposed to be complete in all respect. Ongoing projects to register. To register projects which are prior to 1st August 2017. Projects of 3 Rs, not involving marketing, advertising, selling, or allotment. What is the 3 Rs means? 3 Rs means if there is a repair, renovation, or redevelopment of the society and there is no sellable area, so they don't have to go for the RERA registration. Mr. Promoter, let's spit it all out. Disclosure in application section 4 subsection 2. Details of project constructed in last 5 years. Authenticated copies of approvals and commencement certificates. Sanction plans and layouts and specification. Initially, builder used to give advance to the landowner, put his board and start collecting money. There were no sanction plans. But now with RERA coming into force, the builder has to upload all the sanction plans on the RERA website, all the layouts and specification, proposed facilities and amenities, numbers and areas of garages for sale. Where promoter is not the owner, agreement entered into between the promoter and such owner. FSI and TDR and other entitlements which are proposed to be utilized. Aggregate area in square meters of the recreation open space. So this is how the transparency and accountability is there in place when RERA is there. Now the builder has to swear. I swear, legal title, there are no accumberances. Date of completion, which normally no bidder used to give the date of possession or date of completion. 70% of the amount collected from the allottees to be deposited in the schedule bank to cover the cost of construction. Why this clause is very important? Because normally builder used to collect the money. They used to first give some advance to the landowner. They'll put the board. They will start collecting the pre-launch money from all the builders in cash or in check, and gullibles home buyers used to get trapped into this, and the builder used to collect the money from the home buyers and put it in some other project. Now with this clause, whatever money is collected in that project, he has to use the 70% of the amount collected from the allottees to be deposited in schedule bank and to cover the cost of construction of the same project. He cannot utilize the money anywhere else. Oops, section 60 will come in place, penalty up to 5% of the estimate cost of project. Section 7, the revocation of registration. Authority may revoke a registration on being satisfied that the promoter is defaulted in doing anything required under the Act, rules and regulation. The promoter violated the terms and conditions of approval. The promoter is involved in unfair or fraudulent practice or irregularities. Consequences: no access to its websites, name of the promoter to appear on list of defaulters on the website, deregistration communicated to the authority in other states, means throughout India, he will be blacklisted, freezing of his bank account with the scheduled bank. What is the status of the project post revocation of registration? See section 8. Section 8, I'll just elaborate on the section 8. Section 8 is that the RERA will form or give an opportunity to all the home buyers, the aggrieved home buyers, that you form an association or society and you take over the project and complete the project, and whatever the unsold inventories are there, the societies can collect the money from selling that unsold inventories and complete the project. So there is no need of, leading the builder by हमारा काम हमारा घर आप करके दो, हमको पूरा करके दो. So the section 8 and 7 is a very crucial. I will have one more seminar only related to section 7 and section 8, that how you should go if you are facing this issue. Functions and duties of promoter, section 11. He has to maintain the website during booking and issue of allotment letter. Now, up to 10%, he has to issue the allotment letter. After 10% of collecting the money, he has to enter into an agreement. Create a web page, enter details as stated in section 4, subsection 2, and quarterly updates on the project. Every 3 months, he has to update what is the progress of the project. Disclose advertisement and prospectus. During the booking and issue of the allotment letter, disclose sanction plans, layout plans approved by the competent authority, that is ROA, that is the right of allottee. Disclose stage-wise schedule of completion of the project, including the provisions of civic infrastructure like water, sanitation, and electricity. Again, this is the right of allottee. Fulfill obligations and functions as stated in the Act, rules, regulations, and agreements for sale. Obtain completion certificate and occupation certificate. Obtain lease certificate where the real estate project is developed on the leasehold land. Form a legal entity like association, society, or cooperative society within 3 months from the date on which 51% of the total number of the allottees in the building have booked their apartments. This is very important. Once the builder books 51% of the total number of units, not even the registered agreement, the moment he books more than 51%, he has to form a society or an association of allottees. Normally, if you see, there are 20 years, 30 years, the builder has not conveyed the land, he has not formed the society, he is running the society or he is running the source till date. With this clause, even if the building is half complete and he sells or books 50% of the total unit of the project, he is bound to form a society or an association of allotment. Pay all outgoings collected from the allottee till physical possession is transferred. not to mortgage or create any charge on property after execution of agreement for sale. Cancel allotment only on terms of agreement for sale. Section 12, allottees. How many of allottees here who have purchased the flat and they want to know what the RERA is going to give them? Now, Section 12, loss sustained due to the incorrect or false statement in the advertisement or prospectus. Now, builder, puts up a very big, large hoardings, give the full page ad, and they give you all the, dreams. But if you have this advertisement and whatever product you get, it is not as per the advertisement, you can take action against the builder under Section 12 because you were promised something and you are getting something else. That is due to incorrect or false statement in advertisement or prospectus or misrepresentation by the builder. Section 13, no agreement for sale, no advance deposit. You can give advance up to only 10%, you will get the allotment letter. The moment you pay more than 10%, you have to execute an agreement. Otherwise, no advance or deposit is given to the builder. Section 14, adherence to the sanction plan. The promoter squad cannot act without the consumer's nod. What is this? Allottees, if the promoter wants to change the plan, he has to take the consent of the home buyers. Arbitrarily or unilaterally, he cannot change the plan without taking the consent of the buyers. Allottees specify and promoters rectify. Section 15, obligation of promoter in case of transfer of a real estate project to a third party. Now, during the course of construction, either he is fed up of the project or he is not able to complete the project and he joins hands with some other bidder either into JV or gives the project or the project is taken over by some other bidder. But the obligation of the promoter in case of transfer of a real estate project to a third party still remains. He cannot say that the other bidder had booked, now I am not responsible. Even the incoming builder is equally responsible as the builder who was initially in the project. Section 16, insurance of real estate project. Transfer of title, conveyance and common area, promise broken, let money apologize, right of allottee, that is we said ROA, interest plus compensation or interest. If the builder, now this section 18 is a very crucial section in which you have two provisions. One provision is, if the builder is not giving you the delivery or the possession of the flat as promised, the first option is you can exit from the project with complete refund and you will get the interest from the date of amount which you have paid in installments. Suppose if certain amount you have paid from 2015, say you have paid 10 lakhs, the interest will be calculated from 2015. The next installment you paid in 2016, say another 10 lakhs. So for that another 10 lakhs, the interest will be calculated from 2016. And plus you have the provision of getting the compensation also. Oops, section 61, contravention of any provision except section 3 and 4 or rules or regulations made penalty up to 5% of the estimated cost of project. Agent, let's know who you are. Initially, in MOFA, the act, the agents, they were not made a party. Now, in this, even the agents who are selling the under construction flats have to get registered themselves from the RERA authority, and they have to maintain all the accounts and books. They have to give the recent photograph, the income tax receipt for the last 3 years, proof of address, details of civil and criminal cases, any pending, validity of the registration. The registration to be valid for a period of 5 years. Bar on registration. No fresh application shall be accepted for a period of 6 months from the date of revocation or suspension of the registration. Functions of real estate agents. Not facilitate the sale or purchase of any plot, apartment or building in an unregistered real estate project. The agent has to be careful. He cannot sell you the plots or flats which are not registered in the project is not registered. Maintain and preserve prescribed books of account and documents as prescribed. Facilitate the possession of all information. Section 62, penalty up to 5% of the cost of plot, apartment, building or which the sale or purchase has been facilitated. So builder cannot cheat the home buyer, neither the agent cannot cheat the home buyer. The other side of the coin, allottees, you are also not exempted. Duties of allottees, that is section 19. Payment to be made as per the terms agreed in the agreement for sale. Delay in payment of above charges will attract payment of interest. Take physical possession within 2 months of issuance of the occupancy certificate. Participate towards the formation of a legal entity with society, association of allottees or cooperative society, etc. Now, many a times, the home buyer was defaulting in the payment. So now the RERA comes into picture. In the agreement now, if the home buyer defaults, the developer used to charge 24% of the interest. Whereas if the builder defaults, he used to give only 9%. After RERA coming into picture, the rate of interest is fixed. That is, the State Bank of India's lending rate, that is today is 7% plus 2%, so 9%. So either builder defaults, he will give 9%, or if the home buyer defaults, he has to give 9%. So the law is same for the home buyer as well as the builder. Authorities under RERA, Real Estate Regulatory Authority. Composition, 1 chairperson and minimum 2 whole-time members. Filing of complaints. Complaint may be filed by the aggrieved person under section 31 of the Act for violation of the Act, rules and regulation. Manner of implementation of orders. In the same manner as if it were a decree or order made by the principal civil court of the original jurisdiction in the principal civil court for execution. Address of hearing of complaints. Bandra East, now this is a little old slide. Now the address have changed. There are 2 different offices now. One is in Bandra East and one is at Churchgate Station. But now due to pandemic, there are no physical hearing going or happening. We are doing all virtual hearing, that is teleconferencing or video conferencing. The period of disposal, that is section 29, which says that within 60 days from the date of receipt of the application. But my dear friends, this doesn't happen in practical. In 60 days, it does not get disposed of. It takes around 120 days to 150 days, which is much better than going into High Court and wait for decades to get the order. Stages of inquiry after filing the complaint. Appearance of party, then recording of plea of the respondent. If he pleads guilty, then the order is passed on the same day. If not plead guilty, then the explanation or reply to be filed by the respondent. Then in the next hearing, leading the evidence or oral or documentary. Then final arguments, and 5th stage is the final order. So if these 5 stages, if you take that every 2 weeks this is happening, so it will take around 75 to 90 days. But I'm being more practical. You say that between 120 days to 150 days. So within 4 to 6 months in RERA, you should get the justice. Consequence of breach of order. Promoter, Section 63, penalty of 5% of the estimated cost of project. Agent, Section 65, penalty 5% of the estimate cost of building, plot, apartment for which the sale or purchase was facilitated. LOT, Section 67, penalty up to 5% of the estimate cost of building, plot or apartment which he has booked. The Real Estate Appellate Tribunal. Now, suppose if you are a home buyer and you are not satisfied with the order of the RERA, then you have to file your appeal in the Real Estate Appellate Tribunal, that is at Kalagoda. Even there also you just have to file your complaint, but even in this pandemic, the virtual hearing is taking place. And it is composed of 1 chairperson and minimum 2 whole-time members, one being a judicial member and the other technical administrative member. Jurisdiction, try appeals from the order and real estate regulatory authority. Period of limitation, within 60 days from the date on which the copy of order is received. Suppose if you are a home buyer and you are not happy with the order of the RERA, so within 60 days, you have to file an appeal in the appellate tribunal. Manner of implementation of orders. Order to be executed by the appellate tribunal as a decree of a civil court. If you are not happy with the order of the appellate tribunal, then within 60 days from the date of communication of the order of the appellate tribunal, you can approach the High Court. Consequence of breach of order. Promoter, Section 64, the imprisonment minimum 3 years or fine 10% of the estimated cost of project or both. Real estate agent, imprisonment maximum 1 year or fine or up to 10% of the estimate cost of plot, apartment, building for which the sale or purchase has been facilitated or both. Section 68, imprisonment maximum 1 year or fine up to 10% of the estimate cost of building or the project or both. Miscellaneous. Bar of jurisdiction. As per Section 79, civil courts have no jurisdiction. Now, suppose if you have a dispute between the builder and you are a home buyer, so you cannot go to city civil court, neither you can go to the High Court. You have to go to the RERA first. If you are not happy with the RERA order, you go to the appellate tribunal. If you are not happy with the appellate tribunal order, then you can go to the High Court. You cannot approach with this type of dispute to the city civil court or to the High Court directly. Cognizance of offense. Section 80. No court shall take cognizance of any offense punishable under this act. Rate of interest payable by the promoter and the allottee. The State Bank of India highest marginal cost of lending rate plus 2%. I explained you in earlier. Nowadays, State Bank of India is charging 7%. So 7 plus 2, 9%. And this applies to both allottee as well as the promoter. Timeline for refund within 60 days from the date on which such refund becomes due and payable to the allottee. So the order, suppose if you get a refund order, the builder has to refund that money within 30 days from the date of which such refund becomes due and payable to the allottee. Parking space. Open parking area, this has been clearly included in the definition of common areas which need to be conveyed to the association of allottees after the occupation certificate is received or to the cooperative society which is registered. Hence, the sale of allotment of open parking areas by the promoter is not permissible as per RERA. Covered parking, as defined in the Act, is permitted to be sold. Garage, as defined in the Act, is permitted to be sold. Judgments on RERA. There are many judgments which we have come across which are going to help you. One is of Messrs. Fortune Infrastructure, known as Econ Infrastructure and others versus Trevor Dilemma and others on March 12, 2018. And in this case, even the Supreme Court held that 3 years is a reasonable time period for construction. Now, what was happened in this case was Trevor Dilemma had approached NCDRC because he's at that time the cost of his flat was more than 1 crore. It was around say 3 crore rupees. He had booked the flat in Bandra and he had paid almost 90 to 95% of the payment, and builder has not started the construction even after 8 years. The NCDRC told that once you have collected the money, so 3 years is a reasonable time, even though the possession date is not mentioned. So 3 years is a reasonable time of period to construct a building. He went to Supreme Court, and Supreme Court also upheld that 3 years is a reasonable time period for construction or completion of a building. So this becomes, when any judgment is passed in Supreme Court, it becomes a law, it becomes a rule. So this is a very good judgment where you have in your allotment letter or in your agreement, if there is no date of possession, this judgment is going to help you a lot. It comes to handy. Then Pioneer Urban and Infrastructure Limited versus Govind Raghavan on April 2, 2019. In this case, the Supreme Court held the buyer can be expected to wait for a reasonable period and not indefinitely. Also, proceedings under Indian Bankruptcy Code 2016, IBC, and RERA can sustain parallelly. Manjit Singh Daliwal versus JVPT Properties Private Limited. This is a fantastic judgment because there were many, confusion that if I have an allotment letter and if I don't have a registered agreement, my complaint for withdrawal will be not been entertained by the RERA authorities. But this judgment observed that complainant filed on basis of allotment letter is valid and complaint of allottees will not fall for want for agreement for sale. If there is no agreement for sale and you have an allotment letter, the complaint is valid in the RERA authorities. So this is a very good judgment given by the appellate tribunal. And if you fall in this category, you can use this judgment. Then Neil Kamal Realtors Suburban Private Limited versus the Union of India on 6 December 2017, writ petition number 2737 of 2017. In this case, Bombay High Court held the provisions of RERA are extend retroactive or quasi-retroactive, and the Parliament has power to legislate even such provisions are not ultra vires to the Constitution. So in 2017, the Bombay High Court said that whatever the RERA is been constituted is legal and nobody can challenge the authority of RERA. So there are various other judgments. We will send it to you on your email address, which we have. You can refer to us. And if you have any queries, and you can let us know. Now I will, this is my number 8928372392. You can note down this number and you can send me the queries on the WhatsApp, or you can note down my this email ID. And now we will take the question answers. Only you have to give me the chat box. What are your questions and answers? And we will take one by one.
So there are a few questions already in the chat box.
Yeah. I'll just go through the questions. Can you repeat one or two questions?
Okay, so I'll read them out.
Yeah.
So the first question is, if project is launched prior to RERA and currently stuck in litigation, how can RERA help to customer to get the refund from builder if project is not registered in RERA?
Yeah. So now even the unregistered project, you can make a complaint to the RERA. Even for unregistered project, you can complain to the RERA. Next question.
In case of society self-redevelopment, what is the effect of RERA? And if society members give society for redevelopment to builder, then what role of society's managing committee?
See, if you have entered into a redevelopment agreement, so if you are an existing member of the society, so you are not an allottee as per the RERA definition. If you take, say, even 10 square feet from the builder and you enter into an agreement, then you become an allottee and then you can file your complaint in the RERA. Self-redevelopment and the redevelopment is a separate topic altogether and a separate subject, which I'm going to take it in the due course of time.
The next question that we have is RERA applicable in case of redevelopment?
No, RERA, I told you, only for the sale component it is applicable, not for the existing members. But if the existing members purchases even a 10 square feet of the area, additional area, and he registers the agreement, he is entitled as an allottee in the RERA and he has the right to file a complaint in RERA. But not if he has purchased.
Okay. The next question that we have is, after winning a case in RERA, still the builder does not pay penalty, then what needs to be done?
See, then there is, you have to file your this thing for the compliance of the order. That is being done digitally. You open your this thing, user ID and password, and then just you have to click the button that for the compliance of the order. And within 60 days, your hearing will be done and he will be penalized. Or the authority will issue an order to the collector to seize his properties and seize his bank account. His bank account will be frozen. Next question.
Can we file a complaint in RERA regarding SRA building?
No. Only for the sale component of the SRA project, you can file a complaint. But if you are a slum dweller and you are an eligible, what you call patra of that particular area, you have no right until and unless you are in a sale component. For the existing member, either in the society or in the slum SRA project, you don't have any right in RERA. Only when you purchase something from the builder, you become an allottee and you have all the right to file a case in RERA.
So another question that we have is, can we file a criminal case also on builder if he doesn't give us possession of area promise?
Yeah, fine. You see, that is a crime. That is a cheating. You can do both. You can have simultaneously both the proceedings going on. One is criminal and one is civil. But you cannot file a complaint in RERA and the civil code and the consumer code simultaneously.
So the next, we have another question. Project registered with RERA equals is buyer tension free regarding title clearance of building. Example, Maradu Kerala building constructed but later it was found that it is in CRZ land. All buildings were to be demolished. So what happens in such cases?
In such cases, you have to file both the complaint in RERA as well as a criminal complaint for breach of trust and cheating. Next question.
Another question that we have is agreement for sale of building under construction and sale agreement for completed project. Is there a difference between the two?
Normally, the schedule of the property and everything will be the same. Only if it is a completed project, you give everything, all the money upfront, right? And if it is a construction, under construction, then the sale agreement will say at this stage you will pay on completion of 5th slab, you will pay so and so amount, on 7th slab you will pay so and so amount, on 9th slab will so and so amount. Otherwise, the agreement is more or less going to be the same. Only the payment schedule will differ.
Okay, sir. Another question is, why are there conflicts between MOFA and RERA? Because my agreement was registered long back.
There is no conflict between MOFA and RERA. RERA, supersedes MOFA also. If your agreement is registered long back and the project is registered in RERA, the builder has not given you the possession, you have all the remedy available in the RERA.
So, what is retroactive in RERA?
Retroactive in RERA is, suppose your agreement was done somewhere in around 2015 or 2014, 2013, 2011, but the project is still ongoing and the project is registered under RERA. So you will get the benefit if you are withdrawing from the project, since it is a RERA registered project. If you have booked in 2011 and you want to exit from the project, so you will get all the benefits from 2011 till the date of money refunded to you. So that is called retroactive.
So the next question is, if society land is given to builder for development, then what role of managing committee in RERA? What is the role of managing committee in RERA?
There is no role of managing committee in RERA. See, you are an existing member. Until and unless you purchase something from the builder, you don't fall into the ambit of allottee, and so you don't fall under the RERA.
So another question is, one promoter formed two firms for two different projects.
Yeah.
When I was searching on RERA website, I have noticed that in the list of promoters, same one person has two different names in two different projects, but the photograph is the same in both projects.
You can complain to the RERA authority.
Yeah, so how and where can we complain?
You have purchased that. You have purchased from any of the project. Are you a purchaser? Are you a home buyer? Then you have the right to complain to the RERA authority that this is the manipulation done by the builder.
Okay, sir. Another question that we have is, what is the role of a tehsildar after RERA order is done?
Yes, it's a very good question. Once the promoter does not comply with the order goes to the collector and the collector sends it to the concerned tehsildar to seize the property of the builder and to seize the bank account of the builder. So that is the role of the tehsildar, to seize the property of the builder, of the defaulting builder, and seize the bank account of the defaulting builder.
So that is all the questions that have come in. If anybody else has any other questions, please post them in the chat box.
I hope everybody enjoyed this session. So should we?
So there's another question that has come up. How much time does the Tehsildar have once he receives the file?
See, he will act immediately. There is no time frame for the Tehsildar, but normally they act within 2 to 4 weeks or 2 to 6 weeks. Only thing is you will have to follow up with the Tehsildar, concerned Tehsildar.
So more questions have come in.
Okay.
Suppose if we get orders from RERA, then is it easy? It is easy to get excited. Normally, how much time it may take and whom to approach?
See, I'll tell you, if you get an order from the RERA, the builder is given 30 days time. But you as a home buyer, you have to wait till 60 days. After 60 days, you have to file a complaint in the RERA for the compliance of the order, that the order is not complied. So there will be hearing will be taken place, and after hearing, the builder will be given one chance. Even to if the builder fails, then the order is sent to the collector to seize all his properties and seize all his bank accounts.
So the next question is, what remedy is available for home buyers in case the property is sealed due to default of builder?
Yeah, then under section 8, under section 7 and section 8, you have to form an association or a society, and then you take over the project.
So the next question is, if builder has got part OC, does he fall out of the ambit of RERA?
No, only up to the, suppose now the building is of say 21 floor, and he has got OC up to the 15 floors. So up to 15 floor, he is exempted from RERA. But up from 15 floor to 21 floor, the RERA is still there. So any aggrieved home buyers who has not got the possession still can file the complaint if his flat is not within the part OC.
So another question is, when the land society is given to builders, then is there any accountability of society in the RERA Act?
No, there is no accountability of the society in the RERA Act. For the society matters, you have to approach to the deputy registrar, divisional joint registrar, and then you can file a separate case in the cooperative code or in the high court or city civil court as per your matter.
So that's all the questions that we've got. A lot of people have said thank you for the webinar and that they've got a good information out of it.
Okay, thank you and good night. Bye.
Thank you, sir. Bye-bye.
Bye.